Today we'll talk about Article 25, 26, 27, and 28. Article 25 we have already discussed. Today in Article 25 we'll discuss what is religion. First thing I want to tell you, the term religion is not defined in the Constitution, and indeed it is a term which is hardly susceptible to any rigid definition. The Supreme Court has defined religion quite broadly. So Supreme Court said that it is a matter of faith with individuals and communities, and it is not necessarily theistic. A religion has its basis in a system of beliefs or doctrines which are regarded by those who profess that religion as conducive to their spiritual well being. But it will not be correct to say that religion is nothing else but a doctrine of belief. A religion may only lay down a code of conduct, code of ethical rules for its follower to accept. It may prescribe rituals, observances, ceremonies, and modes of worship, which are regarded as integral part of religion, and those forms and observances may extend even to matters of food and dress. Religion is essentially a matter of personal faith and belief. So again I am saying that it's a matter of faith and belief. Every person has right not only to entertain such religious beliefs and ideas as may be approved by his judgment or conscience, but also exhibit his belief and ideas by such overt acts which are sanctioned by his religion. Under Article 25, Clause 1, a person has a twofold freedom. We had already discussed these two things, but again I'll repeat because it will help us to further our discussion. First thing, what we have freedom of conscience. The second thing, freedom to, so I have told you what is religion, hopefully you understood it. Freedom to profess, practice, and propagate religion. The freedom of conscience is absolute. What is, so first thing you need to understand what is freedom of conscience. It is absolute inner freedom of the citizens to mold his own relations with God in whatever manner he likes. This is freedom of conscience, that absolute inner freedom of the citizens to mold his own relation with God in whatever manner he likes. आप अपना गॉड के साथ कैसे रिलेशनशिप रखना चाहते हो, उसको कैसे चेंज करना चाहते हो, यही आपकी फ्रीडम ऑफ कंसाइंस है. अब बात करते हैं दूसरी, दैट प्रोफेस, प्रैक्टिस एंड प्रोपगेट क्या होता है. व्हेन दिस फ्रीडम becomes articulate and expressed in outward form, it is to profess and practice religion. To profess, I'll tell you what is the meaning of to profess. What is the meaning of to profess? To profess a religion means to declare freely and openly one's faith and belief. फ्रीली और ओपनली आपने, अगर आप अपना फेथ एंड बिलीफ डिक्लेयर करते हो, इसको कहते हैं हम लोग प्रोफेस. आपने जैसे मान लो कि लेट्स से कि आप कहते हो कि मैं हिंदू धर्म को फॉलो करता हूँ, या फिर आई एम अ मुस्लिम एंड आई फॉलो दिस पर्टिकुलर रिलीजन. तो ये सब चीज़ें आप देखोगे कि इसी को प्रोफेस करना बोलते हैं. ठीक है, कि आपकी फेथ कहाँ है, आप किस में बिलीव करते हो. तो इस चीज़ को फ्रीली और ओपनली अगर आप डिक्लेयर कर सकते हो, इट इज़ कॉल्ड टू प्रोफेस. He has a right to practice his belief by practical expression in any manner he likes. The next thing is to practice. To practice religion is to perform the prescribed religious duties, rites, and rituals, and to exhibit his religious beliefs and ideas, why which ideas by such acts as prescribed by religious orders in which he believes. बहुत सिंपल सी चीज़ है. First thing, that if someone is saying that I am practicing this particular religion, it means that the person is able to perform the prescribed religious duties, rites, and rituals, and to exhibit his religion, religious belief, and ideas by such acts as prescribed by religious orders in which he believes. So, this is the meaning of practice. कुणाल, समझ में आ गया प्रैक्टिस और प्रोफेस की मीनिंग क्या है? बहुत सिंपल समझो कि आप किसी को जाके कि आप किसी को जाके बोल सको कि मैं इस चीज़ में बिलीव करता हूँ, ठीक है, यहाँ मेरी फेथ है, उसको हम लोग कहते हैं प्रोफेस करना, ठीक है. फिर जो आपका बिलीफ सिस्टम है उसकी कुछ रिचुअल्स होगी, राइट्स होगी, ठीक है. हमारे यहाँ भी जैसे मान लो हिंदुज़म है, ठीक है, तो हिंदुज़म में बहुत सारे रिचुअल्स राइट्स हैं, लोग फॉलो करते हैं. मुस्लिम्स में भी हैं, क्रिश्चियंस में भी है. तो जैसे कुछ लोग चर्च जाते हैं, कुछ लोग मॉस्क जाते हैं. देयर आर सम पीपल हु गोज़ टू टेम्पल्स ऑल्सो, वहाँ पे जाके जो पूजा परफॉर्म करते हैं. सो ये सब चीज़ें आती हैं रिलीजन की प्रैक्टिस में, कि आप रिलीजन को प्रैक्टिस कर रहे हो. समझ में आ गया प्रोफेस और प्रैक्टिस में क्या डिफरेंस है और क्या होते हैं? द नेक्स्ट थिंग दैट आर्टिकल 25 इंक्लूड्स, इट इज propagate. What is the meaning of propagate? To propagate, it means to spread and publicize his religious view for edification of अदर्स. सिंपल होता है कि आप कोई चीज़ आपके रिलीजन में प्रैक्टिस करते हो, ठीक है, तो आपने वहाँ जाके बोलना शुरू किया कि ये हमारे रिलीजन की जो है इतनी अच्छी चीज़ें हैं, जिससे कि लोग थोड़े बहुत इन्फ्लुएंस हों. अब इन्फ्लुएंस का मतलब ये नहीं है कि फोर्सफुली इन्फ्लुएंस करना है. जैसे मान लो कि मैंने आपको अपने कोर्स के बारे में बताया, ठीक है, कि ऐसा ऐसा है ईजिंग यूपीएससी में, मैं ये सब चीज़ें आपको करवाता हूँ, ठीक है. आपको पूरा डेली टारगेट देने के बाद जो है डिस्कशन हो गया, एक क्लासेस टाइप का सिस्टम हो गया, इसके बाद में वीकली आपको टेस्ट हो गए, ठीक है. तो ये सब चीज़ें करता हूँ. तो मैंने एक तरीके से आपको क्या किया, आपको अपना एक तरीके से पब्लिसिटी की अपने प्रोग्राम के बारे में. आप कन्विंस हो गए, आपने मुझे पैसे पे कर दिए, ठीक है, एंड यू हैव बिकम पार्ट ऑफ इट. एक चीज़ ये हो गई. दूसरी चीज़ क्या है कि मैं आपके साथ ज़बरदस्ती करूँ. मान लो कि कुणाल है, ठीक है, तो कुणाल को मैंने बताया कि ये प्रोग्राम है. कुणाल को लगा अरे ठीक है चलो. अब मैंने कहा कुणाल की कनपटी पे बंदूक रख के कि कुणाल इसको मेरे प्रोग्राम को बाई करो, नहीं तो मैं शूट कर दूंगा, ठीक है. या फिर और भी दूसरे तरीके हैं कि चलो तुम अभी नहीं इसको बाई कर रहे हो, ठीक है, आगे तुम्हें कभी ज़रूरत पड़ेगी तो फिर मैं तुम्हें मतलब आई ट्राई टू हर्ट यू, या नुकसान पहुंचाने की, जैसे भी किस तरीके से भी आदमी के दिमाग में एक फियर टाइप का क्रिएट करना. तो वो चीज़ एक डिफरेंट है. वो कॉन्स्टिट्यूशन में अलाउड नहीं है, ठीक है। कॉन्स्टिट्यूशन में क्या है कि आप जाके किसी को अपने आइडियाज़ बता सकते हो, आपने अपने रिलीजन के बारे में बता सकते हो, अपने रिलीजन को स्प्रेड और पब्लिसाइज कर सकते हो, ठीक है। जैसे जगह जगह पे जाके आपने बहुत सारी जगह पे, ठीक है, कई जगह पे जैसे एक रामचरितमानस है, तो उनकी जो वर्सेज होती हैं उसको हम लोग चौपाई बोलते हैं लोकल लैंग्वेज में। अब आपने जगह जगह कई जगह जाके मन टेम्पल्स में लोग लिख देते हैं, ठीक है, उनकी जो एक लिटरल मीनिंग होती है वो भी लिख देते हैं। तो अब अगर आप उसको पढ़ के इन्फ्लुएंस होते हो, ठीक है, और आपको लगता है कि नहीं ये रिलीजन ठीक है, तो आप उसको एक्सेप्ट कर लो, या उस व्यू को आप एक्सेप्ट कर लो। ज़रूरी नहीं कि आप उसका हिस्सा बन जाओ, बट यू कैन एक्सेप्ट कि हाँ ये चीज़ भी ठीक है। तो प्रोपोगेट करना समझ में आ गया आपको कि क्या होता है? बेसिकली परसुएट करना, ठीक है, परसुएशन एंड एक्सपोजिशन, परसुएशन एंड एक्सपोजिशन विदाउट एनी एलिमेंट ऑफ कोअर्सन। इस चीज़ को आप याद रखना, देयर शुड नॉट बी नो कोअर्सन। So, the right to propagate one's religion does not give a right to convert any person to one's own religion. इस चीज़ को आप याद रखना कि कन्वर्जन जैसा कुछ है नहीं हमारे यहाँ कॉन्स्टिट्यूशन में कि आप को कन्वर्जन कर सकते हो आप किसी का। आप किसी को बताओ, कोई अपनी इच्छा से एक्सेप्ट कर ले वो एक अलग बात है, बट आप किसी को कन्वर्ट होने के लिए नहीं बोल सकते हो ना, आप उसको कन्वर्जन करा सकते हो अपनी मन से। And there is no fundamental right to convert any person to one's own religion. So you can ask me that what article 21, sorry, 25 clause 1 guarantees. It simply guarantees is not right to convert another person to one's own religion, but to transmit or spread वंस रिलीजन बाय एन एक्सपोजिशन ऑफ इट्स टेनेट्स। आपके जो रिलीजन के टेनेट्स हैं वो आप लोगों को जाके बता सकते हो। आर्टिकल 25 गारंटीज फ्रीडम ऑफ कंसाइंस टू एवरी सिटीजन एंड नॉट मियरली टू द फॉलोअर्स ऑफ वन पर्टिकुलर रिलीजन। It therefore postulates that there is no fundamental right to convert another person to one's own religion, because if a person purposely undertakes the conversion of another person to his religion, as distinguished from his efforts to transmit or spread the tenet of his religion, that would impinge on the freedom of conscience guaranteed to all citizens of the country alike. तो आपको मैंने रीज़न भी बता दिया कि क्यों कन्वर्जन अलाउड नहीं है। देन द प्रोटेक्शन ऑफ आर्टिकल 25 एंड 26 thus not limited to the matter of doctrine of belief. It extend also to act done in persuasion of religion. तो आपका एक बिलीफ सिस्टम नहीं है, आपने अपने रिलीजन को परस्यू करने में क्या एक्ट किए हैं। इट ऑल्सो कवर्ड अंडर आर्टिकल 25 एज वेल एज 26. Therefore, it contains a guarantee of rituals, observance. This thing I have already explained to you. Again, I am telling you, repeating. Observance, ceremonies, and mode of worship, which are integral part of religion. What constitute and now there is a point. There is one thing that what constitute a religious practice. So, who will decide that what constitute a religious practice? Anyone? Can you please tell me who will decide that what constitute a religious practice?
Sir, are you talking about essential religious practices? मतलब
Yes. Who will decide?
जैसे वो कृपान कैरी कर सकते हैं, that is a necessary practice, like
हाँ यही सब
Supreme
मैं
Court
बात कर
said
रहा
as
हूँ
such.
कि कौन डिसाइड करेगा। अब जैसे मान लो कि एक क्या कहते हैं, जैसे जनेऊ धारण करना, ठीक है। तो अब जनेऊ धारण करना एसेंशियल प्रैक्टिस है या नहीं है, ठीक है, रिलीजन की। तो इस टाइप की चीज़ें, जैसे कुछ लोग तिलक लगाते हैं, तो तिलक लगाना रिलीजियस रिलीजन की एसेंशियल प्रैक्टिस है या नहीं है। तो हु विल डिसाइड दैट दिस इज एसेंशियल प्रैक्टिस और नॉट?
Sir, ultimately it should go to the court of law, I think.
Yes, yes. So what constitutes an essential practice of religions or religious practice has to be decided by the courts with reference to a doctrine of a particular religion and includes practices which are regarded by the community as a part of its religion. This much is clear or not? So hopefully you understood this concept, right? Now we heard this case, abolition of triple talaq. So a little bit we'll talk about it. There are a lot many things, but those things are not important from the perspective of UPSC. Therefore, I am not telling. Otherwise, I mean, we can discuss acquisition of place of worship, shifting of property connected with religion. Then we can discuss appointments of non-Brahmin as pujari in temple, abolition of hereditary right in temple, telecast of serial. The, these are lot many things that we can discuss, but from the perspective of prelims and mains, they are not much relevant. Therefore, I'm not telling you. Abolition of triple talaq. So there was this case, Shaira Vano versus Union of India. In this case, the Supreme Court, by majority of 3-2, three judges were in favor, two judges opposed it, declared triple talaq, or its name is called also talaq e biddat. Talaq e biddat, being instant and irrevocable. So it was instant and irrevocable. So court declared it unconstitutional. Court said that talaq biddat is a kind of talaq effected by one definitive pronouncement of talaq, such as I talaq you. It is irrevocable, or three simultaneous pronouncement like talaq, talaq, talaq uttered at the same time. So court declared it unconstitutional. Court said that this is irrevocable practice and therefore it's unconstitutional. Now there were things like noise pollution in the name of religion. It's not allowed. So if you want me to tell you, I can tell you. So there was this case in Church of God in India versus KKRMC Welfare Association. So here Supreme Court held, in the exercise of right of religious freedom under Article 25-26, no person can be allowed to create noise pollution or disturb the peace of others. This thing is important because here and there we hear in this news that this that use of loudspeaker during the religious practice. So this thing we hear. So that's the reason I'm telling you. So the custom of religious prayer through the use of loudspeaker is not an essential element of any religion. Listen carefully. The order of authorities under the Madras Town Nuisance Act 1889 and the Noise Pollution Rules 2000 is valid and constitutional. The direction given by the High Court to the authorities to follow guidelines for control of noise pollution issued in 1995 and to make church to keep speakers of lower level are legal in view of pollution control provision. ठीक है. तो अगर कोई कहता है कि वही हमें लाउड स्पीकर यूज करना इज़ अ फंडामेंटल राइट, ठीक है, इट्स अ रिलीजियस प्रैक्टिस, देन इट इज़ नॉट रिलीजियस प्रैक्टिस। अब भाई आज से 500 साल पहले अगर लाउड स्पीकर नहीं होते थे तो क्या रिलीजियस प्रैक्टिस होती नहीं थी क्या? आप बताओ मुझे, होती थी कि नहीं होती थी? जो प्रैक्टिस आप फॉलो करते चले आ रहे हो वो तो करते ही चले आ रहे थे। अब अगर 500 साल पहले कौन सा लाउड स्पीकर था, तब कैसे करते थे लोग? तो ये तो सब आपने लोगों ने एडिशन कर दिया, और एडिशन जो आप कुछ भी करते हो तो ये एक्सेप्टेबल नहीं है ना। यहाँ तक आपको समझ आ गया? चलो अब हम लोग रेस्ट्रिक्शंस की बात कर लेते हैं। Restriction on freedom of religion. First, religious liberty subject to public order, morality, and health. In the name of religion, no act can be done against public order, morality, and health of public. There is this section of IPC, that is section 34. Sorry, there is this section of Police Act. Police Act 34. It prohibits the slaughter of cattle or indecent exposure of one's person in a public place. These acts cannot be justified on a plea or practice of religious person uh, in a what did I tell you? Okay, I was talking about police act. So I was telling you that certain acts like indecent exposures or slaughter of cattle, so these acts cannot be justified on plea or practice of religious rights. Likewise, in the name of religion, untouchability or traffic in human beings, for example, system of devdasi as it was prevalent in South India, cannot be tolerated, and this freedom is also subject to the other provision of this part. That's it: the right to freedom of speech and expression, freedom of assembly and association, freedom to carry on a profession, trade, and business. The freedom to practice religion cannot affect the exercise of these freedom by others. These rights are subject to the reasonable restriction under clause 2 of article 19.2. Hopefully point is clear. We'll talk about little bit forced conversion also. So there was a case. What happened in this case? The validity of two acts, Madhya Pradesh Dharm Swatantrata Adhiniyam 1968 and Odisha Freedom of Religion Act 1967. These two acts were passed by the legislature of Madhya Pradesh and Odisha respectively, and they were challenged on the ground that they were violative of the fundamental right of appellant, that is guaranteed under Article 25(1) of the Constitution. Now, what was the purpose of these acts? The purpose of these acts was to prohibit forcible conversion of any person to one own's religion. So basically, the appellant was prosecuted for the commission of offense under the Madhya Pradesh Act. He contended that right to propagate one's religion meant the right to convert a person to one's own religion and was a fundamental right under Article 25, Clause 1 of the Constitution. Then the state legislature had no competence to enact such law as it did not fall within the purview of Entry 1 of List 2 and Entry 1 of List 3 of the 7th Schedule. It was covered by Entry 97 of List 1, so Parliament alone had the power to make the law and not the state legislature. Then, rejecting this contention of the appellant, the Supreme Court held that the impugned act falls within the purview of Entry 1 of List 2 as they are meant to avoid disturbances to the public order by prohibiting conversion from one religion to another in a manner reprehensible to the conscience of the community. And these two acts do not provide for regulation of religion and therefore do not fall under entry 7 of list 1. So list 1 is union list. If a thing that disturbs the current of the life of the community and does not merely affect an individual, it would amount to disturbance of the public order. Hopefully point is clear. Second restriction, regulation of economic, financial, political.
So,
Yes,
so the first restriction was the liberty being subject to certain public order,
yes.
morality, and health. And you mentioned the forced conversion. It was sub part of public order maintenance, or it is a specific restriction.
It's a part of public order.
Public order only. Okay.
अभी जैसे मान लो क्या होता है कि किसी ने किसी का कन्वर्जन करवा दिया फिर हंगामा खड़ा हो जाएगा तो पब्लिक ऑर्डर की सिचुएशन आ गई ना. दो चीज़ें मैंने बताई थी आपको. पहला रीज़न बताया था कि कॉन्स्टिट्यूशन क्यों डिनाई करता है, ठीक है. फिर एक केस हुआ तो केस में क्या कहा गया कि भाई ये पब्लिक ऑर्डर के अंदर चीज़ नहीं आती है. ये चीज़ तो जो है कंसाइंस की बात है. तब कोर्ट ने कहा था इट कैन क्रिएट ए सिचुएशन ऑफ पब्लिक ऑर्डर ऑल्सो फोर्स्ड कन्वर्जन. ठीक है. Second thing is regulation of economic, financial, political, and secular activities associated with religious practices. It's a clause 2A. So basically, the freedom to practice religion extend not only to those activities that are the essence of religion. It does not cover secular activities which do not form the essence of religion. And it is not always easy to say which activities fall under religious practice or which are of secular, commercial, or political nature associated with religious practice, and therefore each case must be judged by its own facts and circumstances. एक तीसरा है सर 2B, Clause 2B. So, under Clause 2B of Article 25, the state is empowered to make law for social welfare and social reform. Therefore, under this clause, the state can eradicate social practices and dogmas which stand in the path of the country's onwards progress. Such laws do not affect the essence of any religion. This clause declares that where there is conflict between the need of social welfare and reform and religious practice, religion must yield. Social evils cannot be practiced in the name of religion. Now, we have this prohibition of bigamy, and there are a lot many things. So these things are not important, therefore I'm not going to discuss. But there is this one explanation that we can discuss. So there is this one explanation one. It talks about a right of Sikh to wear and carry kirpans. The right of Sikh to wear and carry kirpans is recognized as a religious practice in explanation 1 of Article 25, but it does not mean that he can keep any number of kirpans. He is entitled to keep one sword. He cannot possess more than one kirpan without a license. Remember this thing. There is one more explanation 2. So let's discuss that also, and we are done with Article 25. Hindu and Hindu religious institution. Explanation 2 of Article 25 provides that reference of Hindu shall be construed as including a reference to person professing Sikh, Jainism, and Buddhism religion, and reference to Hindu religious institute shall be construed accordingly. तो ये चीज़, ये दो एक्सप्लेनेशन थे, मैंने आपको ये बता दिए. अब हम लोग डिस्कस करेंगे फ्रीडम टू मैनेज रिलीजियस अफेयर्स. Article 26. Article 26 provides that subject to, again, public order, morality, and health, every religious denomination or any section thereof shall have the right, first, to establish and maintain institutions for religious and charitable purpose. Second, to manage its own affairs in matters of religion. Third thing, to own and acquire movable and immovable property, and to administer such property in accordance with law. Again, I'll repeat that 26 provides that subject to public order, morality, and public health, every religious denomination, every religious denomination or any section shall have the right to establish, so they can establish, maintain institution for religious and charitable purpose. Second thing, to manage its own affairs in matters of religion. Third, to own and acquire, so they can own and acquire movable and immovable property. And the last one, to administer such property in accordance with law. Okay, now what is religious denomination? This is the important thing that you should know. Anyone, if you have any idea about what is religious denomination?
सर जैसे कोई बड़ा रिलीजन है उसके अंदर से कुछ सबसेक्ट कल्ट निकल जाना उसमें से मतलब
अच्छा, चलो इससे पहले मैं एक चीज़ बताता हूँ. द राइट गारंटीड अंडर आर्टिकल 25 इज एन इंडिविजुअल राइट. ठीक है, 25 इज अ इंडिविजुअल राइट. While right guaranteed under Article 26 is the right of an organized body like the religious denomination or any section thereof. Now, if we see this term in terms that what there is in the dictionary, so the word denomination has been defined as a collection of individual, collection of individual. Classes together under the same name, generally a religious sect or body having a common faith and organization and designated by a distinctive value. The words religious denomination in Article 26 must take their color from the word religion, and therefore it must also satisfy three conditions. The first condition is that it must be a collection of individuals who have a system of belief which they regard as conducive to their spiritual well being. That is a common faith. Second condition is it must have a common organization, and the last one is it must be designated by a distinctive name. Therefore, in the large sense, Hinduism is a denomination in contradiction to Christians and Muslim, and in limited sense, the various philosophies governing Hindu society. For example, we have Advaits, we have Dvaits, we have uh, Sabites, we have Vaishnavites. Okay, so these are also be termed as denomination. Point is clear or not? There is a Anand Marg. So this Anand Marg is also a religious denomination within the Hindu religion. Hopefully, point is clear that what is the meaning of religious denomination. Now we'll talk about right to establish and maintain institutions for religious and charitable purposes. Under Article 26, Clause A, every religious denomination has right to establish and maintain institution for religious and charitable purpose. The words establish and maintain in Article 26A must be read together. So these two things, establish and maintain, they must be read together. Therefore, it is not only those institutions which a religious denomination establishes which can claim to maintain it. There was this case that Aziz Basha versus Union of India. So in this case, the Supreme Court held that Aligarh University was not established by the Muslim minority and therefore it could not claim the right to maintain it. It was established under the statute passed by the parliament. Next thing, right to manage matters of religion. Under Article 26B, a religious denomination or organization is free to manage its own affairs in matters of religion. The state cannot interfere in the exercise of this unless they run counter to public order, health, or morality. Accordingly, every religious denomination or organization enjoy complete freedom in the matter of deciding what rites and ceremonies are essential according to the tenets of the religion they hold. The court has right to determine whether a particular rite or ceremony is regarded as essential by the tenets of a particular religion or not. So this is what court can do. Hopefully this point is clear. Next, right to administer property. There was one more point. What point we are missing?
Sir, own and acquire movable and immovable property.
Yes, own and acquire movable and immovable property. Okay, all right. So these two things we'll discuss together: right to own and acquire movable or immovable property, and right to administer property owned by denomination. These two things we'll discuss together. So under clause C and under clause D of Article 26, a religious denomination has a right to acquire and own property and to administer such property as per the law. The right to administer property owned by a religious denomination is a limited right, and it is a subject to regulatory power of the state in clause 2a of article 25, and also any general property. There is a clear distinction between the right to manage its own affairs in a matter of religion and right to manage its property by a religious denomination. The right of religious denomination to manage its property has been placed on a different footing from the right to manage its own affairs in matter of religion. We have already discussed, so I'm not going to discuss this. What is right to religion? Right to manage its own affairs in matter of religion. So the former is a fundamental right which cannot be taken away except on ground mentioned in Article 25, while the latter can be regulated by law, that is, it can be abridged or taken away by a valid law. So basically, right to administer property can be taken away, but right to manage its own affairs of religion, it cannot be taken away. It has certain exceptions like health, public order, morality. These things are there. Apart from these things, it cannot be taken away. The right under clause C and D of Article 26 are confined to the existing right to administer its property, where they had already been vested in a religious denomination. These rights that are available under clause C and clause D, they do not create any new rights, but they simply protect the continuance of the existing right. So it can only regulate by law with a view to improve the administration of property for the better utilization of the endowment of property. So this is in Article 26, the C and D. Now we'll talk about Article 27 and thereafter we'll discuss Article 28. So we'll take a break of 10 minutes and thereafter we'll discuss Article 27.